Well, everybody has different opinions about what the verdict should have been in the Karen Reed case. Some people feel that she should have been guilty. Some feel that she's guilty of sin. Some people feel that she should have been acquitted. And my objective opinion after seeing all the evidence come in was that she should have been acquitted. Definitely the Commonwealth did not meet their burden of proving beyond a reasonable doubt that she committed the crime. Now, some people may feel that even though they did not satisfy their burden, they just still feel that she was the one who did it. They were in a fight and, they point to other things. But if you just look at the evidence and you think about the burden, the legal burden, what is required to prove in this case, I think as a lawyer watching this trial from beginning to end, that the evidence shows that she should have been acquitted and the Commonwealth did not meet its burden, which is most likely why they hired a new prosecutor, and this new prosecutor is scrambling to get experts to contradict some of the ARCCA experts, and he's putting out more subpoenas, he's getting some more discovery because they want to build a stronger case. Now, for certain people, the evidence that pointed to Karen Reed's innocence was the fact that they collected some of the blood in Solo cups. That was a big problem with the investigation, and that nothing was recovered, and no pieces of tail that were recovered initially, and then they were only recovered later, and what was going on between, and what was going on with the car, and all the different inconsistencies with the stories. Where was Brian Higgins' car? Was he parked between the cars? Was he in front of the cars? How many times did Jennifer McCabe look out the window, and the time problems, the time discrepancies, and did the phone record some extra steps? There was a lot of problems with this case, which pointed to Karen Reed's innocence. And I will say that what really did it for me, what was really the nail in the coffin for me, which I felt, well, that was it. That's it. There's nothing really more to argue. Once I saw this, and there's no refuting that by the Commonwealth, was the ARCCA experts. The ARCCA experts, the biomechanical engineers, which were extremely highly qualified experts who said that, just simply put, scientifically, the injuries to the vehicle and the injuries to the damage to the vehicle and the injuries to John O'Keefe do not match up. And therefore, it's inconsistent with the narrative that the Commonwealth is providing that Karen Reed backed the car out. It's inconsistent. The damage to the vehicle, the injuries to John O'Keefe, they're just inconsistent with each other. So the pushback that I've been getting from certain people who feel that either Karen Reed is guilty or feel that I'm relying too much on the ARCCA experts is the following. They asked the following question, which I think is a worthwhile question to discuss, which is what I'm going to be discussing in today's video. And that question is, well, the ARCCA experts only came to their opinion when they were provided certain materials. They were only provided a selected amount of materials. They even said themselves, they even testified, their reports say it, that they're only coming to this conclusion and they reserve the right to amend and change and edit their conclusions if they get more materials to review. So after all, if they're only provided with select amount of information, and that's where they come to the opinions based on, well, then doesn't that leave open to the possibility that they were not provided with all of the information? And I will say that this is a common tactic on cross-examination. When you're cross-examining witnesses, I've used this myself. When you talk to the expert about what materials they've reviewed, what materials they were not provided, why weren't they provided certain materials, I've done this myself, and I understand the strength of that line of cross-examination. So let's discuss if that is a good line of cross-examination, and if it's a good argument, and maybe I'll take back my reliance on these ARCCA experts. So first, let's show you some clips of what they were provided. So first we have to discuss what they were provided, and then we'll talk about what they were not provided. So let's pull up the clip right here. This is the first ARCCA expert. His opinion was with respect to the damage to the vehicle. The next expert was in relation to the damage to John O'Keefe, his injuries. So let's hear first what he was provided to review in order to come to his conclusion.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you?
Okay, so that was everything that he was provided in order to come to his conclusion. So photographs, some medical records, some police reports. That's what he used. He had a lot of photographs. He had videos of the car. He had pictures of the Lexus, and he had obviously pictures of and medical records and the autopsy report of John O'Keefe. So that's what he based his conclusions on. So now, before we move on to what he didn't have, let's see what the other expert had, what he had to rely on before he came to his conclusion. So let's go to 328, about right there.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail light, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolf, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So there we go. He also very, very clearly laid out everything that he had to base his opinion on whether these injuries are consistent with being hit by Karen Reed's car going in reverse, right? So there we have, again, all the medical records, the pictures of John O'Keefe's injuries, the pictures of the Lexus, the damage to the vehicle, the police reports, and their testing that they've done. So they relied on all that in order to come to their conclusion. Now let's take a look at what they didn't have. So let's see what Adam Lally brings out in cross-examination of the first guy. Let's move it up to, I'm sorry, I forgot his name right now.
Question correctly, yes. If the vehicle is striking the center of gravity of a pedestrian as opposed to just, for instance, the limb, yes, the center of gravity or the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle, is that correct?
It wasn't necessary.
So he didn't look at the defendant's vehicle, but he did say that it wasn't necessary for him to look at it.
And did you look at the actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
So he didn't look at the physical taillight, but then he's responded, well, I had enough photographs. I don't need to actually look at the physical taillight. So he's saying that even though I didn't see that, I didn't have that evidence to look at, I didn't need to because I had the pictures and that was sufficient for my analysis.
Did you ever look at the actual physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
Okay, so then you're right. He didn't have those pieces of evidence. He didn't have certainly the forensic DNA reports, which also Lally brought out. He didn't have the state's reconstruction report. We all remember Trooper Paul talking about his reconstruction efforts. So he didn't have Trooper Paul's report about what he did. And this we just heard that he didn't actually see the physical vehicle and the physical pieces of broken plastic from that vehicle, from the taillight. So, but he did kind of explain why it wasn't really necessary. But anyway, just for completeness sake, let's move up to Lally's questions on the next expert about what he was not provided. So this is going to be a little up here. Here we go.
Physical car, is that correct?
I did not. That's correct.
So you just asked him, you never looked at the physical car. And he said, yep, I never looked at the physical car.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
So again, he did bring out that, you didn't actually inspect the physical vehicle. And his response was, yeah, I know it wasn't necessary in this case to actually look at the vehicle. I had enough, again, the same thing as a previous expert. I had enough pictures already. I didn't need to actually look at the physical vehicle. So that was his response to that. And now people have also been saying, well, what about, any other evidence that he didn't look at or future evidence, maybe that would have changed his opinion. So let's take a look at what he says with respect to that. So a little bit further, but we'll play a little
The
bit.
ground could cause it or not. The roadway could cause it. The curb could cause it. A back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided, isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
So there you go. He's saying that all the evidence that he did have, though he didn't have some of the evidence, but even when he became aware of the evidence after, that still did not change his opinion. There's still just simply not enough evidence to come to the conclusion that that Karen Reed's car hit John O'Keefe. Now, again, they don't have to prove, if you're Karen Reed, you don't have to prove what did cause the injury. All you have to prove is that what the Commonwealth is suggesting, their idea of what happened here, there's just no evidence to support that. If there's no evidence to support that, and there's been no evidence offered in this case, and that's exactly what he just testified to, that all the evidence that he's seen even after he came to his conclusion. So that still does not explain what happened in this case, because again, the injuries are inconsistent. Now, let's just go on a limb here. Let's just try to play with the argument a little bit and just logically analyze the argument. Well, maybe there's other evidence. Maybe they just simply weren't given certain other pieces of evidence. Okay, so let's just talk about that, just to be fair to that side, and logically talk about whether that's a good argument. Maybe there's some evidence out there that they were not given. So number one, we do know that they did not actually inspect the actual vehicle. These two experts acknowledge they did not actually inspect the vehicle. Now, they've both said very clearly it doesn't matter that they didn't. It wasn't necessary. They had sufficient evidence from the pictures, and it wasn't necessary. And let's think about what their job is. Let's think about what their expertise is. Their expertise is to try to reconstruct this scenario and then it equal the damage to the car. So just think about logically, what do they need as experts to reconstruct this scene, reconstruct this accident, and for it to equal the damage to the vehicle and the injuries to John O'Keefe? And let's think about what other pieces of evidence they would potentially need that can change this analysis. Well, obviously they need to see the damage to the car, right? That's obviously the ABCs. They have to know what the damage to the car was. So that's number one. They have to know what damage. Now, they had pictures of the damage. They know exactly what damage was caused to that car. Okay, so they know that. Number two, they have to know the injuries that were caused on John O'Keefe. So they've got pictures of the injuries. They got his medical records. They have everything that's necessary to diagnose his injuries as it relates to any sort of impact from that vehicle. So they have the injuries. They have the pictures of his injuries. They have the pictures of the car. Now they are given a task: reconstruct this scenario in where it's possible that the damage to the vehicle is consistent with the injuries to John O'Keefe. So use all the science and math that all the physics that everything that possibly, all of your expertise to try to figure out how the damage to the vehicle that we were giving you all these pictures of, the damage to the vehicle. Now, of course, if there's additional pictures that are saying, oh, look at this, there's more damage to the vehicle that we didn't realize when we gave you those pictures. Oh, yeah, certainly their analysis can change. But assuming that the pictures of the vehicle, of that shattered taillight, are accurate, and that's probably all included in the report, and there's been no suggestion that they were not given accurate pictures of the damage to the taillight. But if for somehow there was some more damage to the vehicle that nobody knew about and that wasn't presented in evidence, and now they're going to give them those additional pictures and say, oh, look, there's actually more damage to the car that you didn't realize. The pictures were off, the lighting was off, and there's something corrupted about the pictures of the videos. Okay, so then they didn't get an accurate picture. Then you can make possibly that argument. But if they were given the pictures of accurate pictures of the vehicle, and they were given accurate pictures of his arm, which there's nothing to suggest that they weren't, well, then that's really essentially all that they should need. What else can you imagine? What else can you think of? For all the people that are making the arguments, well, they weren't given all the materials. What other materials can possibly there be for them to change their opinion? Again, the two main important factors here are the damage to the vehicle and the injuries to John O'Keefe. What more really do you need? I'm just, so of course, Lally tried to bring out, well, you didn't have the DNA forensic reports that showed that there was a piece of hair on that vehicle, right? Yeah. What's that going to change anything? That still doesn't change the science between the force that's required by this car to cause a certain damage to somebody else's body. Whether the person has a piece of DNA of his here or there or not, who cares? How does that really change the equation? So it's one tremendous big speculation to say, well, maybe there's some other evidence out there that they weren't given. The only evidence that Lally can identify that they didn't have, which even afterwards he said, after I became aware of that evidence, it still didn't change my opinion, but the only evidence that they didn't have was the actual inspection of the vehicle itself, the DNA forensic reports, and the state's Trooper Paul's reconstruction report, which, okay, he doesn't need that. He doesn't need to see what somebody else's reconstruction report is, and certainly someone who is extremely less qualified than he is, what his report says, because he's got all of the factors necessary to run a reconstruction. Now, I also want to say one other thing, and that is the following. I think people are misunderstanding terms over here. The way that doctors and experts, the way that they work is when you give them something to review, they're always going to leave an avenue open for themselves. They're never going to lock themselves in to a specific position and never leave any way out. This is true by any expert. For example, if you give me a bunch of paper, you give me a file, you come to me and you say, you know what, I think I have a great case against somebody else, a civil case. I have a case against somebody, ran a red light and smashed into somebody who had the right of way, and now that person's suffering terribly, and we should be able to sue that other person. Okay, so you give me this file. Now I look at this file, and I come to the conclusion that the police report says that actually the person had the green light, and the person really wasn't as injured as you say he was. He was really fine. He went to the hospital. Everything checked out fine. The x-rays were negative, and the CT scans were negative. Everything's fine. And I look through that file. I'll say, from my review of the file, this is what I'll say if you hire me to do this. I'm not going to say you don't have a case. Finished. There's nothing to talk about. I'll say, from my review of the materials that you've given me, the police report, the pictures, the medical records, from the review of the report from all the files that you gave me, my conclusion is the following. And of course, if there's any additional materials, I reserve the right to change my opinion. That's what any expert is going to do, because, who knows? Maybe you got the wrong medical records. Maybe there's the pictures were off. Maybe there's some other crazy fluke situation in which maybe something will get changed. So, but realistically speaking, if that's an accurate police report, which there's nothing to suggest that there's not, and that's accurate pictures that were taken, and they're accurate medical records, so then, yeah, I can comfortably say, yes, this is absolutely my conclusion, but just no expert does that. So it's just something that people are getting misunderstood because they don't understand how experts talk. They don't understand the lingo that they use and the fact that they always give themselves a way out. They always say this is subject to, if I get more information, more materials, I may change my opinion, and that's gonna change everything. So they always leave themselves a way out. But again, in this case, if you tell them right now, I'm telling you right now, there's nothing changing about the pictures of the vehicle, the damage to the vehicle. I'm telling you right now, absolutely, there's no question that nothing's changing about the injuries to John O'Keefe. Everything that you reviewed is 100% accurate. there's nothing that would change their opinion. It's very, very hard to imagine what she kept saying, that hurdle. You can't deny the science here. And they have enough information for the science. It's just the way that they write the reports will say that they'll say that, we're going to leave our ways. We're going to leave it open that we do reserve the right to amend our report if necessary. But again, the way that they talk is that there's simply not enough evidence from what we reviewed. That's how experts talk. So from what I reviewed, there's not enough evidence. That's just how they talk. And it's another way of saying, anybody who understands experts, understands doctors, that's just another way of them saying, yes, you're 100% right. There's nothing doing here. That's just the way that they just talk a little bit differently. So again, I'm trying to be as logical and open-minded as possible to think what other possible factor could have been factored in here, absent a manipulation of the materials that was given to them. What can possibly change their opinions on this? So they always leave it open just in case there's some crazy situation that will arise. So that's why they're saying it. But looking at this case, from what we've seen, what we've presented in this case, you can't, as a jury, speculate, oh, well, maybe there's something else, and therefore just ignore the ARCCA opinions because it's subject to, they may change their opinion of some evidence that they were never given and was never produced during trial. So that's why I think it's still safe to say that I am still of the conviction that based on these experts, these ARCCA experts, the Commonwealth just simply did not meet their burden to prove beyond a reasonable doubt. And like I've said before, the state now is going to be looking for experts. They're looking for now additional experts to counter these experts. That was the big, obvious problem. I mean, any trial lawyer would have told you that Trooper Paul cannot be going up against these experts. You need real experts, real biomechanical engineers. So that's what this new prosecutor is seemingly trying to do, get other biomechanical experts to contradict these ARCCA experts. But then again, like I've said before, even if they get experts to contradict them, so then you have experts against each other. So that doesn't prove your case. The ARCCA experts are still most likely going to hold by their opinion unless there's some crazy more information they became aware of or that gets presented to them. So if you just have the ARCCA experts against some other experts that the prosecutor is able to pay enough money to contradict them, you're still going to have a question in your mind. If you're a juror, you should still have a reasonable doubt which expert is right. And that's a reasonable doubt. So then the Commonwealth hasn't proven their case. So that's what I see as of now. And like I'll say to you, I'm reserving my opinion if anything changes, because that's just the way professionals talk. So that's going to be it for now. Thank you all for watching. If you haven't yet, please subscribe, like, and we will see you next time.